Hello everyone. I would like to welcome you all to the Lawyers Wit Season 2 lecture series. Today's webinar is brought to you in collaboration with the Virtual Lawyer. Over the course of this month, we'll be conducting a number of webinars on all relevant topics of law. Today, I'm proud to present a webinar on the topic of dispute resolution, MSME 2006 Act, by our very coveted and respected speaker, Mr. Tariq Ahmed Khan, who's an advocate at the Delhi High Court. Now I call upon Ms. Nishu Gupta to give a short introduction about Ms. Tariq Ahmed Khan.
Thank you, sir. Shall I start?
Yep.
Yes, please.
Thank you, sir. Good evening, everyone. My name is Nishu Gupta. Thank you for joining us today. We are proud to present the webinar today on the topic Dispute Resolution under MSME Act 2006 by our special speaker, Mr. Tariq Ahmed Khan, sir. We welcome you, sir. Tariq sir completed his graduation from Faculty of Law, Jamia Millia Islamia in 2014. He specializes in international and domestic arbitration, MSME disputes, commercial laws, writ remedies, etc. He is currently working as a principal associate with Advani and Company, Barrister at Law, New Delhi, and has also been appointed as secretary to the Tribunal for SIAC Arbitration. Sai is also representing various multinational corporations and well versed with trial procedure, research, drafting, and civil litigation. He is also a guest faculty in various law colleges across Delhi and NCR, including Indian Law Institute, and Sir is currently working on his next book. Recently, Sir featured in Fortune 500 India magazine on special issues of 2017 and 18 for authoring the bestseller On the Rise, publishing by Universal Law Publishing. In 2017, All India Reporter Association conferred on him the title of Shah-e-Awad. He is a columnist and made it to the conference around of Judge Advocate General. He is associated with various NGOs, commission, and is frequently invited by law colleges across the country for interactive sessions. Sir also have more than 20 publications, had gained more than 10 awards. We are happy to have you, sir. We are so glad to get this opportunity. You are always inspired us with your article, session, and book. I welcome you, sir.
Thank you so much. Thank you, Nitu, for such a nice introduction. Today, first of all, I'd like to thank Lawyers Wit and Virtual Lawyer for giving me this opportunity. It is indeed a very interesting discussion because the topic, there's not much literature on this subject, and it is something on which you will not find a lot of information on the internet also, because many people have asked me, they've sought certain clarifications in relation to Micro, Small, Medium Enterprises Development Act of 2006. So today I'll be briefly covering all the relevant sections of the Act and what is the step-by-step procedure to be followed in relation to any dispute resolution under the MSME Act. Now, you all are well versed with Arbitration Act, but the MSMED Act is slightly different. And though there is a procedure for dispute resolution under the MSMED Act under Section 16, under Section 18, but it is very different from the way arbitrations are conducted contractually by invoking an arbitration clause. So I'll just briefly tell you what is MSMED Act. MSMED Act stands for Micro, Small, Medium Enterprises Development Act. This is the Act of 2006. So when this act came, before this act, there was another act which was into the picture that was taking care of interest on Small Industrial and Undertakings Act. That was the Act of 1991. The reason for bringing MSMED Act was promotion, development, and facilitation of these micro, small, medium enterprises. If you look at the object, you will understand. And the reason why this is a priority for the government also and for the ministry is because a lot of these enterprises run a risk of becoming sick industries, because if their payments are not made in time, then they do not have a very large capital, unlike these big multinational corporations and the companies with huge investments in in their machinery, in their plants. So micro, small, medium enterprises, basically what these entities are, it is defined under Section 7 of the Act. I will take you back from 2006. I will be discussing the recent amendments later, but I will first start with what was the actual law. So as you know that a lot of entities which are doing small business, and a lot of, I think the Indian economy is dependent on MSME sector quite a lot. So there are certain benefit of being registered as a MSME, either a micro, small, or a medium enterprise. So you know about the collateral free loans which are provided by the banks. That is one of the major advantages of being registered as a MSME. And that's why a lot of entities want to register themselves as a micro, small, or medium enterprise. The other benefit that you can get by becoming a micro, small, or medium enterprises is that on patent registration, you get a subsidy. So that's another advantage that you get. Apart from that, you get concession on electricity bills, you get protection against delayed payments. But today I will be only discussing with you, not the commercial aspect of MSMEs, but I will be discussing everything in relation to the Act of 2006. So the reason why this protection of delayed payments is given is because many buyers, so there are two individuals that we'll be dealing with under the Act. Under Section 2, that is the definition, you will find buyer being defined and a supplier also being defined. These are the two important definitions which you must understand to understand the whole Act. So supplier is basically somebody under the Act which is defined under Section 2N. Any entity which is rendering services or is in the manufacturing or production of certain goods. So it can either be for manufacturing of goods or rendering any services. These were the two broad categories under the Act of 2006. So under Section 7, criteria has been defined as to who will be a micro or a small or a medium enterprise. So if you look at Section 7 of the Act of 2006, it basically divides the criteria in two parts. One is the category of manufacturing. So those entities which are into manufacturing, their investments in the plant, in the machinery, if it is up to 25 lakhs, the investment in their machinery, then they will fall in the category of a micro enterprise. If their investment in the machinery is more than 25 lakhs, but less than 5 crores, then they will be falling in the category of small enterprise. Similarly, if an entity is having investment in machinery more than 5 crores, but less than 10 crores, then it would fall in the category of a medium enterprise. This is on the basis of the manufacturing. Now, the other category of individuals who are entitled to the benefit of MSME Act would be rendering services. So there may be entities which are not manufacturing, but are merely rendering services. So if you look at the other category in Section 7, because I told you it's divided in two parts, the criteria for rendering services is slightly different. The investment in is lesser than that. So 25 lakhs to 2 crore, then 2 crore to 5 crores. So 5 crore is the upper limit for being a medium enterprise. So that's the small distinction which I wanted to highlight. You can refer to Section 7. I will not be going too deep into this because today's discussion is going to revolve around Section 18 essentially, which is the most important provision of the MSMED Act, which deals with dispute resolution. But I will make it a point because this is a very small act. There's not a lot of literature on it. So I will try to cover all aspects in this very discussion. So I have told you that Section 7 talks about the classification of these MSMEs, that how to identify which entity is a micro or small or medium enterprise. Now, straight away going to the important definition, which is Section 2N. So if you look at Section 2N, it defines supplier. So supplier will be basically the MSME, either a micro or a small entity, which is making supplies to a buyer. And that's how, when you will read the important provisions of delayed payments, it will all make sense to you. But let me just quickly go through the definition. Section 2N says that supplier means a micro or a small enterprise which has filed a memorandum with the authority referred to in subsection 1 of Section 8. Now, this is very crucial because a lot of jurisprudence and case laws have been, judgments have been pronounced on this aspect, because this has become the most important, the root cause of all the issues arising in the MSME Act, that who is a supplier and whether that person will get the benefit of the act or not. Now, section 2N says, firstly, that you have to file a memorandum. Now, memorandum has to be filed by the entity under section 8. So I will straight away take you to section 8 because I don't want to miss on any of it, and I'm taking you step by step, trying to draw an analogy. Section 8 says any person who intends to establish a micro small enterprise may at his discretion, a medium enterprise may at his discretion, shall file the memorandum of micro, small, or as the case may be, of medium enterprise with such authority as may be specified by the state government under section 4. So basically, section 8 talks about the registration of these MSMEs. Registration is a very crucial aspect. If you are not registered, you may not be able to get the benefits of the act. And that's why there were a lot of hurdles faced by many entities which were not registered as a micro, small, or medium enterprise with the concerned authority because they did not file a memorandum, though they did satisfy the criteria of section 7 of classification, and their investment in machinery was according to section 7. But since they were not registered under 8, they faced difficulty in getting the benefits of the act. Now, quickly coming back to section 2N again, which talks about the definition of a supplier. I will come to the reason why definition of supplier is the most important definition under the act. But quickly before that, so one category I have told you that if you want to be a supplier under the act, you need to be registered. This is how the section 2N start. Now, there is one very interesting thing which is written and includes. If you look at 2N, it says supplier means a micro or small enterprise which has filed a memorandum with the authority under section 8. So this is one category. And then it says and includes. Then there are 3 subcategories. One is National Small Industries Corporation. Second is the Small Industries Development Corporation. And the third is any company or cooperative society by whatever name called or registered for the time being enforced and engaged in selling goods produced by the micro or small enterprises and rendering services which are provided by such enterprises. So section 2N says that one is that obviously if you have filed a memorandum with the authority under section 8, then you are a supplier under the act. So you may be a micro or a small enterprise as per section 7, but you become a supplier when you qualify as a supplier under section 2N. So for being a supplier, a micro or small enterprise will have to first file a registration with the authority, which is called a memorandum under section 8. That is one way of being a supplier. The other way of being a supplier is because the definition says that it is inclusive and includes. The words of these two words is very important usage. And includes 3 categories. I have told you the third one is very important, where it says any entity by whatever name called, but which is rendering services which are provided by the MSMEs. Now I'll tell you what was the essential benefit, why there are people who want to go for MSME arbitration and they do not want to go for normal arbitration. So I'll put it simply and I will discuss with the relevant provisions later on. So the simple law is that if I am registered as a micro or a small enterprise, if the buyer is not making my payments within 45 days, then I will be entitled to 3 times the bank rate interest. So the RBI has a circular which has monthly rest, the rate of interest. So as per those prevailing rates of interest, I will be getting compounding rate of interest, which is 3 times the bank rate. So in a normal arbitration, you get interest, which is as per the normal standard practice. It may be 8%, it may be 10%. Whereas in a case involving a micro or a small enterprise, if the arbitration is conducted under the MSME Act, the rate of interest becomes so huge that now people have started calling this act as a draconian law. Whereas, however, I call it a welfare legislation because it is for the benefit of micro, small, or medium enterprises so that their money is not taken away from them. The legitimate dues are clear. The payments are made to them. Now you straight away come to section 15, 16, 17. These are the most important provisions because if you want to look at the benefits of the act, you will have to go to section 15 straight away. Now, when I see section 15, I will read 15, 16, 17, all of them together, because this is the part which is chapter 5, which talks about delayed payments to micro or small enterprises. Section 15 says liability of a buyer to make the payment. Where any supplier supplies any goods or renders any services to any buyer, the buyer shall make payment therefore on or before the date agreed upon, and when there is no agreement in this behalf, before the appointed day, provided that in no case the period agreed between the supplier and the buyer in writing shall not exceed 45 days from the day of deemed acceptance. So even if there is an agreement between a buyer and a supplier that I will be making payments to you, the period has to be less than 45 days. You cannot make an agreement that I will make you payments after 2 years. The agreement also has to be 45 days and not beyond that. So in any case, payment of these MSMEs has to be made within a period of 45 days by all the buyers. Now, the interesting thing to look at is that the usage of word in chapter 5 is not a micro or a small enterprise. The usage is where any supplier. Therefore, it can be safely deduced that the benefit is accrued to a supplier, not to a micro or a small enterprise per se. That's the language. So you may be a micro or small enterprise, but if you do not qualify to be a supplier under section 2N, you may be deprived of the acts, the fruits of this act. Similarly, if you look at section 16, it talks about the date from which and rate at which interest is payable. So this says, notwithstanding anything contained in any agreement between the buyer and supplier or any law in force, shall be liable to pay compound interest with monthly rest to the supplier on the amount. This would be 3 times the bank rate notified by the Reserve Bank of India. So now it is clear that even if the agreement between buyer and supplier says that no interest shall be payable, because a lot of times we have seen in agreements there are such clauses, or if there is a clause which says that interest should be 8%, so all of these things will have no value, because as per the statute, which is a special legislation, it says that interest shall be 3 times the bank rate interest, compounding. Now coming to section 17 quickly. So 15, 16 I've explained you. 17 talks about the recovery of amount due. So for any goods supplied or services rendered by the supplier, the buyer shall be liable to pay the amount with interest as provided under section 16. Now straight away coming to section 18, which is the theme of the topic today, that is reference to a micro or a small enterprises facilitation council. So in every state, in various cities, you will see MSEFC, which are micro small enterprises facilitation councils. So now the dispute resolution mechanism under the Act is twofold. Firstly, there is a mandatory conciliation, which is to take place in this council, which is essentially for conciliation between the buyer and supplier under the Act. So suppose I'm a supplier under the Act and I'm not getting my money from the first thing that I have to do is I have to file a claim before the conciliation body, which is called a reference. So I will be filing a reference under section 18.1. If you look at 18.1, it says, notwithstanding anything contained in any other law, any party to a dispute may, with regard to an amount due under section 17, make a reference to the MSEFC council. So 18.1 clearly talks about the reference which is to be filed before concerned council. For instance, every state may have a different council. You may look at the address online. There's a Samadhan website which provides details and address of all these. Now section 18.2, subsection 2 essentially says that on receipt of a reference, now what will the council do? Once you have filed your claim, so it takes some time because they have a lot of pendency of cases. They shall either themselves conduct conciliation proceedings or seek assistance of any body which is doing such services of conciliation. Ordinarily, what I have seen across the country in various different states in UP, Punjab, Delhi, etc., Nagpur, all of these conciliation bodies conduct conciliation themselves. They do not engage any other body or institute for conducting conciliation proceedings. So when you file a reference before a conciliation body of your concerned state, You will be receiving a notice from them. The buyer will also receive a notice from them. It's a show cause notice in a way that you have to appear before the conciliation body on such and such date. Now, both the parties will be present, and under section 18.2, as I have clarified, that this is a conciliation as specified under 65 to 81 of the Arbitration Act. This is a similar conciliation. Nothing new is there. So once the matter is taken up for conciliation, there are two possibilities. A, the conciliation may fail. B, the conciliation may become successful. If the conciliation becomes successful, it's the end of the matter. But if it doesn't succeed, if conciliation fails, then we look at section 18.3. 18.3 says where the conciliation between the parties fails and it stands terminated without any settlement, then the council shall come and conduct the dispute for arbitration. So I told you initially that it is a two-step mechanism. One is mandatory conciliation. Second step is arbitration. So if the conciliation fails, now the conciliation body, which is the MSCFC of the state, will be conducting arbitration either itself or will be referring the matter to an institute which is rendering arbitration services. Like in Delhi, the practice is the conciliation body, if the conciliation fails, does not conduct arbitration itself, it refers the matter to Delhi International Arbitration Center for conducting arbitration. Now, the interesting catch is that this will be treated as an arbitration which emerges out of an arbitration agreement under Section 7. Because, normally we look at Section 7 of the Arbitration Act to see whether the arbitration clause is valid, etc., etc. So similarly, this will also be treated as an arbitration, which will be identical to an arbitration which is governed under the Arbitration Act. Now, two very important aspects. So I have told you 18.1, which talks about the reference, 18.2, which talks about conciliation to be conducted, 18.3, which says that if it fails, then matter will be referred to arbitration or the conciliation body can itself take up the arbitration. Now coming quickly to 18.4, which is, I think, very important. You will see a lot of judgments. I will be covering few landmark judgments quickly. 18.4 says that notwithstanding anything contained in any other law, the Facilitation Council shall have jurisdiction to act as an arbitrator or a conciliator in a dispute between supplier and a buyer where the supplier is located within its jurisdiction. So the only thing which is to be seen, so if tomorrow you have to file a claim, you will be worried as to where I should file the case because you will feel that cause of action may be in Maharashtra. The supplier, which is the micro or small enterprise, may be situated in Delhi. So you will file the claim, the reference, where the supplier is situated. There may be a clause in the agreement which talks about the exclusive jurisdiction of courts in Maharashtra. But if I am a supplier and I am situated in Delhi, so I will be filing the case in MSCFC Delhi, not in Maharashtra, even if the clause says otherwise. So there was a very important doctrine. There were judgments which have clarified that any private agreement entered into between parties cannot override the Act of Parliament. So this is the Act of Parliament, which says that no matter where the cause of action has happened, no matter where the defendant resides, the only place which will have jurisdiction is where the supplier is registered. So always keep this in mind. This is as per section 18.4. Now coming quickly to 18.5, which says that there is a time limit in which these applications, these references have to be decided. As per section 18.5, the time period for deciding these references is 90 days and not beyond that. The reason to provide this time period is to expedite the whole process of dispute resolution so that the supplier, which is a micro or small entity, should not suffer and the money is quickly released. Another interesting provision is section 19, which talks about that if a buyer or if any entity, not being a supplier, challenges an order of the Facilitation Council or an award which has been passed under the Arbitration Act, then they will have to first deposit 75% of the amount of the award or the subject matter before the court before they can make any challenge. So you cannot challenge any order or any award passed by the council or passed under the MSME Act by an arbitrator without depositing 75. So it's a prerequisite. So that's another benefit which is only accrued to disputes which are being referred and resolved under the MSME Act. Now, another interesting aspect is Section 24. 24 talks about overriding effect of this act. The provisions of Section 15 to 23, which I was reading for you, which are the most important ones, they will override over every other law, whether it is arbitration law, the Arbitration Act, or CPC, or any other act. So when you are reading 15 to 23, and whenever there is a dispute relating to a micro, small, medium enterprise, you straight away have to look at Section 15 to 23, and you do not have to look at what Arbitration Act says, what CPC says, because a lot of these things have in fact been challenged before court in various cases. Now I'll be discussing the process. So when I told you that you'll be filing a case before, I'll tell you how it works in Delhi. So assuming that I get a dispute with a buyer today and I'm the supplier, I'll be filing a claim before the conciliation body, which is the MSCFC Delhi. And then they will take up the matter. They will be sending a notice to both the parties. You can either represent yourself, and general practice is that lawyers are representing the parties in conciliation also. And then the conciliation body, which will be sitting, will tell everybody to get the matter settled, and they will inform the buyer about 3 times the bank rate interest. So there'll be 1 sitting, 2 sitting, maybe sometimes 3 sittings. And the period of 90 days, which has been prescribed under Section 18.5, is not strictly followed sometimes, though as per the Act, it is mandatory. But because the other side may take time that, okay, we are negotiating with them and we need some more time to come up with a better proposal. So it is mostly in the interest of such companies to settle, because they feel that if they unnecessarily delay the matter and contest it, the 3 times the bank rate interest is accruing. And they know for a fact that, in a lot of my cases, I have seen that sometimes the interest became more than the principal. So interest was maybe 2 crores, and the balance, the principal amount was 50 lakhs, 60 lakhs. So, that's one very interesting aspect, and why buyers are very conscious and they're very worried about this act, this law. Now, straightforward, coming to the next step, conciliation fails, what happens then? Then the matter is referred, the order is passed by the MSCFC Council, wherein they will say that, look, the conciliation between these parties have failed, and we are referring the matter to Delhi International Arbitration Center. Now, when the matter is referred to Delhi International Arbitration Center, you have to go to the DIAC, you have to tell them that I'm paying my share of fees. This is my statement of claim. Please appoint an arbitrator as per the DIAC rules. And the matter will then be taken up as any arbitration is taken before the DIAC. You file your claim, they file their defense, you file your rejoinder, so on. But the only thing which have to be kept in mind is that the interest which you will be claiming will be as per the MSME Act and not as per the Arbitration Act or CPC or Interest Act. So you will be entitled to 3 times the bank rate interest. Now, when the award is passed, and if there is a challenge to that award under 34, interesting aspect is that 75% deposit is a prerequisite, which you must remember. The court cannot do away with it. It is because under the Arbitration Act, you have seen the court has the discretion to tell the party that if you're challenging the award under 34, and if you want to stay on the operation of award, you deposit 50% or so on. But here it is 75%, which is mandatory. Now, another interesting aspect of this act. Okay, I'll briefly come to the key issues which are involved in MSME, which you see daily in court of law. A lot of judgments have been passed, but I will be covering briefly the aspects which are there. Now, the most important issue which arose was with respect to the registration of MSMEs. A lot of times what happened, in many of my cases, I've seen that I will be filing my claims before the MSCFC Council, and the buyer will immediately file a writ petition challenging the jurisdiction of the council on the ground that A, I was not informed that they are MSMEs, they are registered MSMEs, otherwise I would have not contracted with them. And B, they say that contract was of 2010, supplies were made in 2011, and they got registered in 2015, contract concluded in 2014, how are they entitled to the benefits of MSME? That's the most important issue which there has been difference of opinion by various high courts. But this is the key issue which has been involved at all times, because every buyer says that you are not MSME. I will go as per the contract agreement, as per the arbitration clause, which has been mentioned in the agreement between us. I will not be going under the MSME Act, because they know that if they go under MSME Act, they will have to pay 3 times the bank rate interest, which they do not want to pay. And therefore, they go to the writ court to get these proceedings stayed. Now, I will tell you 2 very important judgments of Delhi High Court, which have settled the law and brought clarity to this act to a great extent, because Supreme Court has refrained in a lot of matters that I have not seen anything substantial, because this is the law where not a lot of courts have interfered. And I have not seen the Supreme Court till now taking an approach against the MSMEs. All these judgments have favored the micro, small, medium enterprises. And if you look at the 2 judgments which I am telling you, one is Ramki Infrastructure Limited, and the other is GET&D versus Reliable Engineering. So GET&D versus Reliable Engineering is by Justice Muralidhar, wherein he said that a registration, I think in para 32, you may check the para, it may differ, but the crux of the matter was, he said that an entity which is not registered as a MSME does not cease to be one. Registration merely makes availing of these benefits easier. So if I am not registered as a MSME, I may not be able to approach the council, because I have to give that number for them to entertain me as a supplier. The other judgment which I want to tell, and yeah, one more interesting thing in this judgment, what Justice Muralidhar observed was that because the other party said there's a contract between us, there's a dispute resolution clause between us, how can MSCFC have a jurisdiction? To that, Justice Muralidhar observed that under Section 18, there's a clear provision, 18(4), which says that where the supplier is situated, that place will have jurisdiction. So that is where the observation came, that the Act of Parliament cannot be overridden by the private agreement which parties are entering into. So you cannot say, oh no, there is an arbitration clause. However, there is a very interesting judgment by Justice Bobde, I think, Steel Authority judgment, in which it was held that once the arbitration has started under the contract, then later on you cannot say, no, I want to do it under the MSME Act. So because there will be parallel proceedings and they'll be mutually destructive. So if already arbitration has been invoked under the contract, the main contract, and it is going as per that, then you cannot tomorrow or midway, when arbitration is ongoing, you say, no, I want to get it resolved through MSME Council. So that is one thing. But yes, right to approach the conciliation body will always be open. But the arbitration will go on as per the normal contract. The other interesting judgment is the Ramki judgment, which I told you, RAMKY, Ramki Infrastructure Limited versus MSEFC Council. So GET&D is OMP Commercial 76 of 2016. And Ramki is another interesting judgment wherein the same issue was had arisen, that whether an entity which is not registered at the time of making supplies will be entitled to benefits of MSME or not. So there, Justice Bhakru very nicely explained the 4 categories in which Section 2N is divided. So if you remember correctly, I was reading the definition of Section 2N supplier, wherein I told you that first category is where person is registered. If you are registered under Section 8, very well, you become a supplier under the Act. But there are other 3 subcategories. So 1 and 2 are the 2 entities which are government entities which do not have to file any registration. That's what Justice Bhakru pointed out. He said that in the 3rd category of Section 2N, which is 2 and 3, it says any cooperative society, any body, any trust by whatever name called can be categorized as a supplier if it is providing services and goods which are being manufactured by MSMEs. So he said that you will be falling in 2 and 3, and even though you are not registered as a supplier under Section 8, still you will be entitled to the benefits which will accrue to a supplier under the MSME Act. And because it is a welfare legislation, so any such doubt in any case should be, read in favor of the MSMEs, because it's a welfare legislation. Now, there's another issue which had arisen, that whether these MSCFC Council can act as both arbitrator and conciliator, because there is a bar in section 80 of the Arbitration Act that a person cannot act both as conciliator and arbitrator. To that, the courts have given divergent views, but the view which has been adopted is that the act is very clear. If you look at section 18.3 and 18.4, it is pretty clear that if conciliation fails, then the conciliation body can itself take up the arbitration or refer it to any other institute for arbitration. So yeah, there is no bar. That's what was said. And in any case, if you look at section 24 of the arbitration of the MSME Act, it says that it has an overriding effect over any other law. Now, quickly coming to one interesting judgment on seat and venue, which is another Delhi High Court judgment. Justice Naveen Chawla had given the single bench judgment, but later on it was, I think, division bench had given a different view in that. So this judgment is Indian Oil Corporation versus FEPL Engineering. So in this case, what the court said that if you look at section 18.4, it merely provides the venue of arbitration. And if parties have agreed for a seat of arbitration in the contract, then you cannot say that no venue will override the seat. So he said both have to be read constructively, and in conjoint reading will suggest that section 18.4 simply says that supplier is situated, that will be the seat. But if, venue, convenient venue for the supplier. But if the parties have agreed for a seat of arbitration in the agreement, then that seat cannot be done away with. Seat will remain that. So if the seat was Bombay, then it will remain Bombay. But if the supplier is in Delhi, that will be the venue of arbitration. So that's an interesting judgment which has been pronounced by the Delhi High Court. Then another important issue which has arisen is whether Limitation Act is applicable to MSME. The courts have across the country have held that yes, it is applicable. Then the pre-deposit is mandatory requirement or not under the 75% deposit, which I mentioned under section 19. The courts have held that yes, it is mandatory, but court can merely do it in installment. Court has the power to tell you that you don't deposit 75% together, you do it in installment, but it has to be done. It is a condition which has to be mandatorily be complied with. Now we'll straight away come to the recent developments in the MSME Act. Now a lot has changed. There was a notification of 26 June, which was to apply from the 1st of July. I will just pull it out. If you have any issues in relation to this act, I think you all must read this notification. It is super, super important. I will tell you the exact date. Just pull out the notification of 26th June, because now a lot has changed. So if you remember, I told you under section 7, there were two criteria, manufacturing and rendering services. So now it has changed. Earlier, the criteria was that what is your investment in the machinery? That was the criteria for ascertaining as to whether you will be a micro or a small enterprise. But now the criteria has changed, because earlier the problems which people were facing was that people had, suppose 10 years ago, I registered as a micro entity. And 10 years later, which is today, my investment has increased 10 times, but there was no mechanism to keep a check. So I would still fall under the micro category and not small or medium, because my capital has increased, my turnover is increasing. For the recent notification, now the criteria is very different. So now they have made investment in the machinery plus the turnover of this entity to ascertain as to whether this MSME is actually entitled, or it is, because a lot of MSMEs were not getting the benefit, and there were entities which were not actually MSME, but they had registered long back and they were taking benefits, and that therefore depriving the genuine MSME from the fruits of the act. So now the criteria is that you have to show investment up to 1 crore. You will be micro, plus turnover up to 5 crore. So if your investment in the machinery is up to 1 crore and your turnover, annual turnover is 5 crore, then you will be a micro entity. Then if your investment in machinery is from 1 crore to 10 crores, then you are a small entity. Also, you have to satisfy that your turnover should fall in 5 to 50 crores. So now there are two criteria. Now the only criteria is not investment in machinery, this has to be coupled with the annual turnover of your company. So suppose my investment in my machinery, my plant is 80 lakhs. I have invested 80 lakhs in my machinery and my annual turnover is 2 crores. Then I am definitely falling in a micro enterprise. Similarly, if my investment in the machinery is 5 crores and my annual turnover is 10 crores, then I will again look at this classification and I will be a small enterprise. The only issue which may exist is that in one criteria, suppose my investment in machinery is 80 lakhs, which is satisfying the micro classification, but turnover is more than 5 crores, which is falling in small category. So for this purpose, if my any of the ceiling is crossed, then I will be put in the next category. Then I will not be micro, I will be small category. So this is very crucial to understand that if you cross any of the two, namely the investment in machinery or the turnover ceiling, then you will immediately fall in the next class. So if you were earlier being categorized as micro, then you will be considered as a small enterprise for all practical purposes. Now, how do you ascertain as to who has invested how much in the machinery? So for that, your ITR and your invoices of machinery will be considered, whether these were second-hand invoices of machinery or whatever it is, but your invoices will be looked into. And for calculation of your investment in the machinery, your ITR will also be relevant of previous years because you declare what are your assets and everything. Similarly, for turnover, they will be referring to the GST and they want you to compulsorily give your PAN card also. You will have to link all of it. Now, these are the recent developments so that nobody can take undue advantage of the act and only genuine MSMEs get the benefit. I'm also trying to cover all the questions, Nishu. I'll be finishing in 5-10 minutes, but I'm sure these are the only questions that you'll be having. I'll be happy to answer more, but I'm trying to cover. So I'll finish in the next 5 minutes and then you can ask me any questions that are still left. Now, as I told you that uh, classification is based on two criteria, namely the investment in the machinery and the annual turnover. And how it will be ascertained, that also I have explained to you. Your ITR of previous years, your PAN card, your GST, all of that will be relevant in ascertaining that. Interesting thing is, if you are exporting, your exports will not be included for the purpose of turnover. So this is another reason to encourage and promote exports. So you will still be a micro if you are, even though your annual turnover is increasing because of your exports that you are doing. So export amount will not be included for the purpose of calculating your turnover. Okay, last thing, how do you register yourself? So today, if I want to register myself as a micro or a small enterprise, it's a very simple procedure now. There is a Udyam registration, which has now been initiated by the government. You simply check it online, Udyam registration, UDYAM, and you give in your details. It is based on a self-disclosure basis. The government will presume your figures to be correct. And then you will be immediately receiving an email, which will be an e-certificate. It is called Udyam registration certificate. So the good thing is that you will be disclosing and giving all the information on your own, and nobody is going to verify. You will immediately be registered so that the registration process is not very tiresome. There's no fees payable, but the only thing is that annually you will have to comply. There'll be a check mechanism. You will have to disclose your ITR, your PAN card, etc. that I told you, so that they can see whether a micro enterprise, which was earlier as a micro enterprise, due to the increase in investment in machinery or due to the increase in turnover, is now falling in small. So they will make sure all of those changes are done. And of course, there's a punishment also which they talk about. If you give false declaration, then they will obviously be taking action against you because this is like a fraud that you're playing on them. So that is long and short of MSMED Act. And now I think I'll be happy to take any questions issue if you have. I think I have covered most of it. I hope. Yeah.
Thank you so much, sir, for your precious time and for so much of fruitful session. I have few questions, sir. As you know, sir, MSME Act 2006, Chapter 5, Section 15 to 25 deal the address the issue of delayed payment. Do you think any of these section from 15 to 25 need any changes for better effectuation and better prosecution, sir?
I think that I'll tell you point out one provision. If you look at section 18.5, I think that is the only provision I have a major problem with, because it says that every reference under the act shall be decided within 90 days. Now, it is not clear whether they are talking about 90 days for conciliation, or 90 days for arbitration, or 90 days for conciliation plus arbitration, because they say every reference. At the end of the day, any arbitration also, if it is being referred to arbitration after failure of conciliation, then I don't think it's practical and it is possible to conduct an arbitration and finish it in 90 days, because it requires evidence and it requires a lot of documents to be complied with. And even as per Arbitration Act, the time period is 1 year. And if you look at the even the emergency arbitration or fast track procedure, even that is like 6 months, 4 months, 5 months. I doing something in 3 months is something which is very impractical. So every reference, I think there's no clarity on that. The other can be regarding the period of 90 days is not being strictly complied with, but for the conciliation also. So that is because if you see how conciliations are taking place, it takes a lot of times. And I feel that one change can be introduced, that when you're filing an application before a conciliation body, a lot of times you don't know when your matter will actually be listed. So sometimes it takes 4 or 5 months also. Then what is the purpose of providing such a tight schedule for conducting arbitration? So I think there should be a time limit prescribed for getting the matter listed. So suppose today I file an application, the conciliation body is bound to take it within 30 days, something on those lines.
Yes. Another question, sir, is where do you think the scope of MSME Act and an Arbitration Act starts?
So the scope of MSME, I think, like I told you, if you were talking about from career perspective, what is the scope of MSME disputes and practice, and is that what you're asking?
Yes, sir.
Perfect. So nowadays, I've seen, like you see about the Atmanirbhar scheme, and recently the government has in fact sanctioned huge amounts for this very purpose. And like I said, that our economy is largely dependent on micro, small, medium entities, enterprises. This sector is gaining popularity. A lot of people are in fact into this. Therefore, I feel it's a very I mean, it's always been there, but now with too much of too many disputes and a lot of money of these MSME has been stuck and they're not getting paid. So I think there are too many matters coming up, and I think there's a large scope in future also, because this is an area which has not been explored by anybody, and that's why there is hardly anything on this subject. But I feel that there's a lot of scope, and because of the high rate of interest, which is 3 times the bank rate interest, that's why anybody would prefer going for MSME arbitration rather than going for a normal arbitration. But for that, you of course need to know the law. So a lot of MSMEs were not even aware that such a law exists. But yes, with the recently, I think we are seeing a huge rise in MSME arbitrations.
Last question is, sir, contribute almost 8% of the country's GDP and manufacturing production and 40% of the exports. The government efforts have led to the growth of the MSME and enabled them to counter delayed payments. Do you think, sir, arbitration and dispute resolution have led to the growth of the MSME sector in your opinion?
See, honestly, government has taken initiatives, and I agree that MSME law, the way it is, it actually benefits these MSMEs, and people are actually afraid of keeping the money which belongs to these MSMEs. In fact, if you see, there are notifications which say that all these companies which are dealing with MSMEs will have to provide the data quarterly about each and every payment which has not been made to a MSME, how much money was delayed, how much interest was paid, and all of that has to be done, because when companies are auditing, they have to ensure that this compliance is done. It is mandatory. So government is also keeping a check whether the money of these MSMEs is not being kept by these MNCs, these top companies which are dealing with these enterprises. So yes, in every way, the government is trying to ensure that the money of these MSMEs is not stuck and they don't become sick industries, to promote MSME sector and to develop them. Also, in relation to the role of arbitration and dispute resolution mechanism, yes, the act, the way it provides, and how in Delhi at least it's happening, because a lot of cities and state are not conducting it seriously. But the way the act has been designed and the way it is being implemented. And like I told you, the courts are refraining from going against the any approach which is against the supplier. So all these challenges at the end of the day have not been successful, most of them. So courts have always take pro MSME stance in most of the cases, which is a welfare legislation, and they've read it like that. They have not. I have not come across a judgment which has completely put the MSME Act in a picture as if it is not a good act. So I mean, it's receiving encouragement from everywhere, and yes, dispute resolution mechanism under the act, especially the provision of deposit of 75%, and the fact that 3 times the bank rate interest is payable. All of this is, I think, a blessing in disguise, and that's why I think it is actually encouraging and developing these MSMEs, the MSME sector.
Thank you, sir, for telling us intricacies of this act and for such a fruitful session. Now, I'd like to invite Advocate Gaurav Kumar Chaturvedi to now give the vote of thanks.
Thank you, Mr. Khan. Thank you, Ms. Nisha Gupta. It was great. Mrs. Tariq Khan, an amazing, just a pleasure to have you. It's very nice to hear everything you had to say. It is very interesting. Look, we have heard about dispute resolution from different points of view, but to hear them from MSc point of view is actually very interesting.
Thank you so
So,
much, Govind.
oh, please, sir, you don't have to thank us. We should thank you for such enlightening lecture. Now, without further ado, I'd just like to give the vote of thanks. First and
Yes,
foremost, I would like to thank Mr. Tariq Ahmed Khan for coming and actually taking out the time and talk and preparing for the lecture and giving such a well worded and such a structured lecture. It was interesting and nevertheless it was also very enlightening for me. Now, I would also like to say, whether it be our viewers, our law students, or any budding lawyer, or even experienced lawyers in this particular domain, they would like to hear this lecture and they would like to understand how this particular aspect works. And you also explained how MSMEs are registered and everything. So that's also very interesting. And moving on, I would like to thank Mr. Tarveen Singh Nanda of Lawyers Wit. I would also like to thank you on behalf of the virtual lawyer for coming here. I'd like to thank you to the team of the virtual lawyer, which is Advocate Janvi Sharma and Ms. Nishu Gupta. I would like to thank both of you, all of you, for coming here and just making this a very fruitful and enlightening session. We hope to see you again, Mr. Tariq Khan, sir.
Thank you so much, Govind. Thank you, Nishu. It was my
Thank you
pleasure.
so much, sir.